Welcome, everyone, to the Miller-Johnson January Benefits Lunch Break webinar. I'm Frank Berrodin, and Jeff Gray and Alex Dombrow from our Employee Benefits Group will be doing this month's seminar with me. The first thing we're going to let you know is that if you're not familiar, we do these every month, and here are the dates of the future ones. We don't always have the topics yet because we like them to be timely. As you'll see, this month's is very timely since we've only had a few weeks since the legislation was passed that we're going to be talking about today. And as I'll mention later on, it is very likely that we will be covering this topic in more depth on certain issues in some of these upcoming seminars, but some of them may also be health and welfare or other benefits issues. As always, please let us know if there are any specific things you want us to talk about. We are always happy to talk about anything benefits related. And it very much helps us to know what kinds of things you're wanting to hear about as we prepare for them. So today's topic, we'll get right into it because I think it was 394 pages. So we have a lot to talk about. A lot of it we won't get into or get into in any depth because it's not as important, or at least not right away. And what you're going to find out is that we are going to try to break this into the stuff that's effective immediately, so that if you only have limited time today, you will hear about the most important things that you have to be doing first. And then we will get into some of the stuff that is going to be effective at later times and you have more time to deal with. And so what we're talking about is the Secure Act 2.0. So as you may recall, the Secure Act 1.0, the Setting Up Every Community or Enhanced Retirement Act, which was passed several years ago, made a number of changes to retirement plans. And now this is supplementing that. And you probably, if you attended our firm's seminar, actually in-person seminar this past summer, Jeff Gray talked about a number of these provisions. Now, there have been changes that have occurred since then, and now we have the final law. So we can tell you generally what it provides, but there's a lot of things that will have to be clarified as we go forward. So this passed on December 29th. And as we had been, expecting that, like has happened, I think since the same thing happened with Secure 1.0, was it got passed right at the end of the year as part of a year-end spending bill. And this was generally had overwhelming support. It was not something that was, that the Democrats rammed through while they still had a majority. It got overwhelming support from both parties. So when you hear about the good and the bad of this, and you'll hear lots of bad, at least from me, you don't put all the blame on any one party. They were both responsible for this. So there are a number of changes in the part of this. And, we're going to start out with the first thing, which is, when do you have to amend your plans by? So the good news in some respects is that you have until the end of the 2025 plan year to make these changes. So there's no rush on actually documenting these changes. The hard thing is that Secure 1.0 and the CARES Act amendments and now the Secure 2.0 amendments are all due at the end of 2025. And so Secure 1.0 and CARES Act were effective in 2020. So, you think about people that work in this area that are going to retire between now and then, and they may have all the history of what you've actually implemented. Because the thing we'll talk about today, is a lot of the provisions of this are optional. They're not necessarily mandatory. Some of them are mandatory. So you can start operating your plans based on the effective date of these provisions, but you don't have to document how you're operating it until the end of 2025. Well, that may be a little bit challenging to keep track of all that. So I'm thinking right now, and others may have different feelings, but that we're likely to be amending plans next year in 2024, kind of in the middle of this period, as to when things become effective and when the deadline is. to actually get plans amended so that you have a document that you can follow that reflects how you're actually administering the plan. As obviously it's helpful when questions come up to be able to look at the plan. And if you do that, you wait till the end of 2025 to document it, you really don't know other than knowing how you've been operating. So that will be very helpful. Government and union plans have 2 more years. So it's not until the end of 2027 that you have to document these changes. Now, as I said, I think we're going to be covering this in 2 parts. The first one is going to be the immediate changes in 2023 that are effective. Basically, they were effective when the law was signed. And then the second half of the presentation will be on the things that are in 2024. Some of them are 2025, some 2026. I think that may be about the latest, but maybe there's even something in 2027. So the first thing that I'm going to cover is self-correction of errors, because as we all know, errors are made in retirement plans, despite all of our best efforts. And I can almost guarantee that more errors will be made as a result of this legislation. The biggest thing, they talk, the name of Secure Act 2.0 is actually the Securing a Strong Retirement Act. But what I think it should be called really is accelerating the retirement of people that work in the retirement industry, because that's really what it's going to do. I've seen a lot of message boards and things where people are just throwing up their hands saying, this is overwhelming now, I think it's time to retire. So that's certainly one of the downsides of this new legislation. It has added a significant amount of complexity. And one of the areas that they changed relates to when you make an overpayment from the plan. Now, obviously, this is much more common in defined benefit plans, but it happens in defined contribution plans too. And there's been some good changes to these rules. First of all, you don't have to recover overpayments unless there's a loss to another participant, or if it's a defined benefit plan that is underfunded. So otherwise, and in a lot of cases, the overpayment is small. The employer says, I really don't want to have to go back and get that. In the past, they've generally been concerned about having a fiduciary responsibility to do so. They're now relieved of that. But, you still can recover overpayments if you want to, or if one of these 2 things apply. The other good thing is that it doesn't affect arrangements that are already in place. So especially in pension plans, there are a lot of situations where somebody's benefit was calculated incorrectly and they were receiving an incorrect amount for a number of years. And the employer then finds out and says, okay, we're going to deduct a certain amount from those future payments to make up for the overpayment you received earlier. This will not change anything that's already in place before the act. The bad changes are that going forward, when you're in that situation, there's now very strict rules on what you can't do in recovering those amounts. So if it's gone on for more than 3 years before you catch it, sorry, you can't go back and get those overpayments. You can obviously still correct the payments going forward so the person's getting the right amount, but all the excess they got in the past is just a windfall to them. You can't charge interest or fees on collecting the overpayment. If the participant's receiving payments, the recovery has to be spread out over at least 10 years, and it can't reduce the annual benefit by more than 10%. So you can't get it back very quickly. And you can't use a third-party collection agency or threaten litigation. So the bottom line is, this is very good for participants who have been receiving windfalls. It's not so good for employers getting back the excess money that they paid. Now, the second piece of the self-correction of errors, and this is potentially very good, and that is, as we know, errors get made. All kinds of different errors occur in retirement plans. And there's currently the Employee Plans Compliance Resolution System, and this is an expansion of that program to allow self-correction of all eligible inadvertent failures, as long as the employer has practices and procedures in place to prevent the errors. So this is another reason why it's very important to show that you have those practices and procedures. And okay, errors are still going to occur, but then you can self-correct them. And the only requirements in this provision for self-correction are you have to do it before the IRS discovers it. You have to correct it within a reasonable period of time after discovery. No definition of exactly when that is. Now, the failure can't be egregious. No definition of what that is. And the failure cannot be an abusive tax avoidance transaction. So, that is maybe there's a little more definition of that. But the bottom line is this: if the IRS interprets this the way it appears that Congress has intended, this will be very, very good, because there are many errors that are made that do not fit into the current provisions of the EPCRS, and this would allow you to then correct them, assuming you can meet this criteria. The problem is likely to be that the devil is always in the details, and the IRS does have the authority to issue further guidance on this. As a matter of fact, they're mandated to do it within 2 years, and they may severely limit the language here. I don't think that's what Congress was intending. I hope they don't do that, because I think this could be very good. And I think most employers are willing to correct things when there's a reasonable way to do it. They want to do the right thing. And so this ultimately is something that I'm hopeful will help employers take care of inadvertent failures, because as I indicated before, I can guarantee there are going to be more as a result of this legislation. Now I'm going to turn it over to Jeff, who's going to talk to you about some other changes.
Thanks, Frank. So this is really the first mandatory change that we're talking about for 2023. And this is the change, once again, to the age at which a participant has to start taking required minimum distributions. So in terms of background, if you retire, the IRS requires you to start taking minimum distributions at some point, so that that those tax revenues can start flowing back into the government. You can't just keep that account indefinitely. And so prior to Secure 1.0, that age was basically 70 and a half. So if you retired at age 65, you could hold on to that account until age 70 and a half. And then April 1, after that calendar year in which you turned age 70 and a half, you'd have to start taking required minimum distributions. So Secure 1.0, a few years ago, changed that to age 72. And that was the age we were kind of operating under until recently. Under Secure 2.0, that age now changes to age 73. And that applies to individuals who turn age 72 in 2023. So if you turn age 72 this year, prior to Secure 2.0, you'd have to take a required minimum distribution as of April 1 next year. But now basically that's delayed, because your required beginning age is now age 73. So you wouldn't take an first RMD payment until April 1 of 2025. You'll turn age 73 in 2024. So talk about complication. We don't even have good guidance yet. We have some proposed regulations, but there's still a lot of unknowns about the changes to the RMD rules that were in Secure 1.0, at least with respect to the post-death RMD payments. None of that has been cleared up by this legislation, but this change to the kind of age trigger for RMDs is fairly clear, and it's part of this legislation. I think the one interesting part about this is it seems to be just an error in the way the law is written, that if you're born in 1959, you'd be part of this group where your required beginning age is age 73 and age 75, because beginning in 2033, that age trigger increases from 73 to 75. But oddly, somebody kind of born in 1959 falls in both buckets the way the legislation's drafted. So that will probably be corrected in some sort of future technical correction or guidance. It is sort of interesting, though, that despite all the work that went into that, it seems like there was just an error in how that was written. There are some other RMD changes, not all of which are in effect right now, but we kind of combine them all in the same slide. The first is I think is a good change, right? It reduces the excise tax that normally applies if you fail to take an RMD. That the prior excise tax was 50% of the amount of that RMD payment. So that was a big penalty, big tax penalty, in addition to the normal taxes you pay. That gets reduced to 25% under Secure 2.0, and that's applies right now. You can also reduce that to a further amount down to 10% if you basically fess up to missing the RMD and taking the RMD and paying that 10% to the IRS. I think within 2 years of when you should have already taken that missed payment. So, and historically, the IRS has been pretty forgiving about this excise tax. If it applied to you, you could file for relief with using a form 5329. You could ask for good cause kind of waiver of that excise tax. And our understanding has been that the IRS has been pretty forgiving about that in the past. So it's a question of whether it will still be as forgiving when the penalty gets reduced like this, but hopefully the IRS will be. The next item there is that really lifetime required minimum distributions from Roth accounts are no longer required. That's one of the big advantages of a Roth IRA historically has been that you didn't have lifetime RMD payments. And under Secure 2.0, they kind of made that same rule, that same relief apply to Roth accounts. So I think as a practical matter, we just won't count the Roth account then in determining RMD payments for participants. This takes effect in 2024. There's another provision that applies to commercial. There's a few provisions in Secure 2.0 that really are intended to make annuities more favorable to include them in a DC plan. I think historically certain types of commercial annuities, you really be hard to include them because of the way they're structured and still comply with the RMD rules. So this is kind of a technical change to avoid that conflict between commercial annuities and the RMD rules. Finally, another good RMD change is that surviving spouses could make a one-time irrevocable election basically to be treated as the employee for purposes of calculating RMD payments. That might be helpful. For example, if your surviving spouse is much younger than you, your surviving spouse can say, hey, I want to be treated like the employee, and that could potentially delay the commencement of those RMD payments and even reduce the amount of RMD payments that are required. And so that's effective next year in 2024. Turn it over to Alex. He's got a couple of slides here.
One quick thing, we had a question about what does DC stand for, defined contribution plan.
Yeah.
Just so you know, we use the DC and DB plans in our world. So, yeah.
All right, thanks, Frank and Jeff. We are turning back now to another optional provision within Secure 2.0, but one that has gotten a lot of attention nonetheless. So under Section 604 of this new legislation, employers now have the option of allowing participants to elect to have their matching and non-elective employer contributions made on a Roth basis. So this will mean that contributions made on behalf of employees that are either matching or non-elective contributions will be included in employees' gross income for the year in which those contributions are made. It also means that tax will have to be withheld from some other source of wages when the contributions are made on a Roth basis on an employee's behalf. We expect there to be some guidance coming out in the future on this because there are some issues depending on when you as a plan make the matching contribution, how that tax withholding will work. Another thing to note here is that the Roth matching and non-elective contributions can only be made when those contributions themselves are fully vested. So some plans, if you don't vest your matching and non-elective contributions, won't have the option to offer this unless you amend your plan to make those contributions fully vested, or you would only be able to offer them to employees who are beyond the vesting schedule in the plan. And then another optional change here effective for plan years beginning on and after January 1st of 2024 is the ability to allow your participants to self-certify for hardship distributions. This is something that's been allowed in the past for employees who can self-certify that they do not have other forms of liquid assets to pay for a hardship. Now employers can offer the ability to self-certify that the hardship event itself qualifies under the law and the distribution does not exceed the need of the hardship distribution doesn't exceed the need of the employee. So the 10% excise tax that would normally be charged to a participant for taking an early distribution will be waived if the participant certifies that they have a terminal illness. There are certain requirements that must be met. One being that a physician diagnoses the individual with an illness that will result in death within 84 months. Sufficient evidence will have to be provided to the plan in order to prove that this is the case. Once again, we do not have a definition of sufficient evidence and believe that we will find that in IRS guidance coming up.
So this slide relates to the types of investment options that are allowed to be offered through a 403B plan. Historically, 403B plans couldn't offer some of the options that may be available in a 401k plan, for example, because 403B plans were limited to annuities or custodial accounts investing in mutual funds for the most part. For 401k plans, particularly larger plans, will sometimes invest in what's called a collective investment trust. Those have advantages and disadvantages. One of the advantages is that they tend to be less expensive in terms of management fees than, say, mutual funds. So part of the idea here was to put 403B plans on level footing with other plans and allow those 403B plans to invest in alternative investments like collective investment trust. Unfortunately, for whatever reason, part of the legislation, they didn't address the securities laws that I understand currently prevent 403B plans from making this type of investment. So, there's obviously a drive to make this happen for 403B plans with this legislation, and hopefully there's other changes to the security laws to make that happen. We also have some other, here's just kind of a summary of some optional changes for 2023. One is that you can offer a de minimis incentive for participating in the plan. There's a rule called the contingent benefit rule that generally prevents employers from offering anything to an employee that's contingent on whether or not that employee makes elective deferrals to a plan other than matching contributions. So that's the rule that historically has prevented employers from doing things like this to kind of incentivize participation in the retirement plan. So this is a good change. We don't really know what de minimis means yet, but a gift card to a coffee shop or something relatively small but fun, you could certainly implement to try to drive participation in the 401k plan. The other item here is that there's always going to be employees who are eligible to participate in a 401k plan but don't want to for whatever reason. Technically, if they've met the eligibility requirements, they're still considered a participant for a number of rules that apply to retirement plans, including the obligation to give them legally required notices like the QDIA notice or SPD or SMM. There's a provision in Secure 2.0 that basically says, okay, these people have decided not to participate. You don't have to continue sending them these documents so long as they receive the initial set of documents that you provide to anyone who initially becomes eligible, and that you send them this at least one annual reminder notice that includes a general description of the eligibility rules and a description of the benefits of participation. Now, I don't know if these distributions are kind of automated through your system already. It may be more complicated to stop doing that and start sending the annual reminder notice. I'm not sure, but it's something to talk about. And the way I read it, it's optional. You could continue sending them the full suite of documents if you want. Finally, there's what we call permanent relief for federally declared disasters in Secure 2.0. You can think of the CARES Act, for example, as a type of relief, legislation in connection with the federally declared disaster. We had similar relief for Hurricane Katrina. This basically kind of bakes in that relief going forward whenever there's a federally declared disaster. One big difference, though, is just the amount of the distributions available. CARES Act, you could take distributions up to $100,000. Under Secure 2.0, it's limited to $22,000. And this applies retroactively. It's for any federally declared disasters after February 25 of 2021. Similar to the other relief, it is considered a distributable event, except for DB plans. You can spread the taxation over several years. You can also repay the distribution to the plan. And again, this is optional. The plan sponsor does not necessarily have to provide this. I'll send it back over to Frank.
So we got one quick question on that collective investment trusts and 403B plans, because it is confusing. And I think the bottom line is this act appeared to allow it, but it didn't. They're not currently allowed.
Correct.
So it'll take additional legislation or some clarification. So for right now, you can assume that really nothing has changed until they fix the problem.
Yep.
So that's been confusing and a lot of the stuff you probably read. All right, so I have one more thing to discuss that is effective now, and then we'll move to the 2024 and later. And this is the one piece that is specific to governmental employers. And the good thing from the governmental employer standpoint is that all three of these things are positive changes, nothing negative here. And the first one would have been nice if they had gone a little farther, but you've always had this distinction in 457B plans where you, unlike 401k and 403B, where you can have elective deferral changes made at any time, they had to be effective on the first day of the month following the time you made the election. That has now been eliminated for governmental 457B plans, not for tax exempt 457B plans. Once again, I see errors all the time on the differences between governmental 457Bs and tax exempts. So here's another thing that's a distinction between the two where I expect there will be mistakes made. But this is at least good for governmental. I wish they had just done it for all 457B plans. The second is there's an exclusion from gross income that's currently in existence for distributions of up to $3,000 for health and long-term care premiums of public safety officers. And currently, or prior to the act, they could only be made, these payments could only be made directly to pay those premiums. They have now said you can make the payment to the participant as long as they certify that the distribution qualifies for the exemption, essentially that they will use it to pay those premiums. So that's another beneficial thing. And the last one is the exemption for the 10% penalty on early withdrawal for certain public safety officers now applies after 25 years of service, even if you're not age 50. It previously only applied if you were age 50. And it's also been extended to correction officers and certain forensic security employees. So that's all that's currently effective. Now we're going to jump to the things that become effective in 2024 or later years. And the first thing that I'm going to cover is also an important one, and this is significant. So Secure Act 1.0 added this new requirement that you have to cover part-time employees if they have worked for 3 consecutive years with over 500 hours a year. Well, Secure 2.0 now changes that to 2 years, but it makes it effective 1 year later. So basically, as of 1/1/24, we're going to have the same rules in effect that if you've worked 3 years, you're going to have to enroll these part-time employees. And beginning in 2025, that drops to 2 years. So you'll have to let in a few more people in potentially at that time. The important things to understand here is that just like Secure Act 1.0, all you have to do is allow them to make their own contributions. There is no employer contribution requirement for these part-time employees. So it's not, a little bit of an administrative issue letting them in early, but you don't have to worry about making contributions for them. The one thing that Secure Act 2.0 has done, which has been a significant improvement, once again, it didn't go as far as I would have liked. I would have liked to see the top-heavy test eliminated completely because I think it's unnecessary now with all the other tests they've layered on. But they at least said that going forward, beginning in 2024, you can run a separate test for the excludable and non-excludable employees. So this is why a lot of smaller top-heavy plans have not allowed these people into their plan because they were concerned they would have to make a top-heavy contribution for that. So now you can run a separate test and basically treat those employees that would be otherwise excludable as, and then they would then not have to get the top-heavy minimum contribution. So I do think for more and more plans, the result of this may be that it just might make sense to eliminate all waiting periods and just let everybody start contributing right away. Because even if you're a top-heavy plan, you won't necessarily have to make a top-heavy contribution for them, which has been the most significant cost to allowing that to happen. Another significant change, though I'm not sure it'll affect many of the people listening to this, because if you're listening to this, you probably already have a retirement plan, in which case this doesn't apply. Automatic enrollment provisions, automatic contributions are great features. I strongly encourage employers to have it. Originally, there was a proposal to make every plan have to include them. And certainly there are some employers that it's been problematic to do so. So they do have a mandatory requirement now, but it only applies to new plans established after January 1, 2025. It does have, certain requirements that they have to meet in order to provide the automatic contribution and automatic enrollment. And there are exceptions, though, for obviously existing plans, new plans established by businesses that have been in existence fewer than 3 years, ones that have fewer than 11 employees, and governmental and church employers. So bottom line, this isn't going to apply to very many employers, which is a good thing. But I still it's not a reason not to look at adding automatic enrollment and automatic increase provisions. You just don't have to do that right away.
So another significant change is this provision that permits employers to make matching contributions on behalf of participants for what's called qualified student loan payments. The background to this is that for several years, employers have realized that their incoming workforce is really overloaded with student debt, and that puts them behind in their retirement plan savings. So instead of making contributions to their 401k or their retirement plan, they're putting it towards paying off student loans. A number of years ago, a company we believe is Abbott Labs had requested a private letter ruling from the IRS, basically approving of a non-elective contribution to employees who were making student loan repayments. So you'd make a flat percentage of compensation, non-elective contribution to these participants, whether they're participating in the plan or not, and regardless of the amount of there were some limits on their student loan payments, but that private letter ruling could only apply to the entity that requested it. So you couldn't really add this non-elective contribution to your own plan without taking some risk that your plan might be slightly different than what the IRS approved. In any event, that conversation continued about what do we do for these folks that have a lot of student loan payments. And an outcome of this legislation is that employers can basically treat those student loan payments as elective deferrals for purposes of calculating matching contributions. It applies to 401k plans, 403b plans, simple IRAs, governmental 457b plans. We're still going to need maybe some guidance about what a qualified student loan payment is. The provision in the statute allows the employee to self-certify that they have qualified education expenses. Generally, that term about the qualified student loan payment term comes from a separate statute. So we know how that's defined, and participants can self-certify that they have one of these loans. I think the trick is going to be having the mechanical, wherewithal to track those loan payments and calculate the matching contributions. There are some companies that, ever since that Abbott Labs decision came out, there are some companies that do have the software that allow you to do this. So those companies already exist. So I think this is a good thing. We do have some time to kind of get ramped up for it. It won't take effect until next year, January 1, 2024. Also, if you're concerned about, there's always the risk of, well, we're making matching contributions. these participants aren't making any deferrals. Are we going to have a problem passing non-discrimination testing? And the rules give some relief in that regard by allowing you to test this group separately. And also, there's some other provisions in this section of legislation that are intended to prevent some kind of a testing failure by virtue of you offering these loan payments, matching contributions on loan payments. Another change is the increase in the catch-up contribution limits for a certain band of participants, basically age 61 through 63. So, the normal rule is if you reach 50 by the end of the year, you can make catch-up contributions for that year. Under this rule, if you're between the ages of 60 and 63, your catch-up contribution basically increases to 150% of the normal catch-up limit that's in place for 2024, and that'll be adjusted periodically for inflation. If we had used 2023 as an example, 150% of the current catch-up limit, that would be $11,250 would be a catch-up limit for somebody within this band between 60 and 63. So unless there's huge deflation or something, the lower limit of $10,000 probably not going to apply anytime soon. We'll usually be looking at that 150% number. And so this is effective for plan years beginning in 2025. We also have Roth. Another change to the catch-up contributions is this mandatory characterization of catch-up contributions as Roth contributions for certain participants above a certain compensation level. So basically, if you have FICA wages over $145,000, your catch-up contributions will have to be made on a Roth basis. Why we have, another dollar limit, seemingly random dollar limit, I'm not sure. They didn't use the highly compensated employee definition. Instead, it's $145,000. So basically, if you have compensation above that, you have to make your catch-up contributions on a Roth basis, which means the plan is going to need to offer Roth contributions. If it doesn't, then catch-up contributions may not be available for this group of employees with that level of compensation. This change is effective for 2024.
I'll give you my 2-second commentary on that one. It was ridiculous that they did not use the same definition of highly compensated employee for that. Talk about errors being made. Now you've got this separate 145,000. You've got a definition of highly compensated employee that right now is very close to that. It just makes no sense to me.
Yeah, it seems like it's a lot of these Roth provisions are all just designed to generate revenue. And so some actuary did some math and decided that was the number they needed to use for that particular revenue raiser, I guess. But it's frustrating.
Okay, so another change that was made effective for plan years beginning after January 1st of 2024 is an increased cash out limit. And this is on the mandatory cash out limit for former employees and also applies to beneficiaries. So as of right now, if a plan participant has an account balance over $5,000 or a beneficiary is entitled to that plan account over $5,000, then they can continue to maintain their accounts in the plan under certain situations. The new legislation taking effect will increase that number to $7,000, meaning that if the participant's or beneficiary's account is at $7,000 or below, you can force them out of the plan with a single lump sum or by rolling their account balance into a IRA or a qualified retirement plan rollover. Another change effective beginning for plan years after January 1 of 2024 is the ability for 401k, 403b, and governmental 457b plans to add what they are calling a retirement plan emergency savings account to the plan. So this will work in a couple of different ways, and the employer will have the option of choosing either automatically enrolling individuals into this portion of the plan at a 3% contribution rate, or offering the option to employees to make their own contributions into this section of the plan. One thing to note here is that contributions will be capped at $2,500 starting in 2024, and that number will be adjusted for inflation. Another thing employers can note is that they can terminate this portion of the plan at any time. So if you begin offering it and it doesn't seem like individuals are taking advantage or it becomes an administrative headache, you have the ability to kill the savings account at any point and distribute what participants have contributed at that point. The distributions will work the same as Roth distributions. So all contributions to the plan will be made on a post-tax basis.
One other thing that I just wanted to add is we didn't really talk about that because of this change on the catch-up contributions being Roth, it pretty much means every plan is going to have to offer Roth if they want to allow catch-up contributions. And so we still do have a few clients, not a lot, I think, that don't have Roth as available under their plan. I think you really have to do that if you're going to allow catch-up contributions going forward.
Yeah, I think so too. I don't think we've run into, well, it sounds like the record keepers, they seem to be able to add Roth without a huge headache. And the clients I know that I've had that have added it, I haven't heard that there've been huge kind of errors that they didn't anticipate in doing it. So it might be, I know we have some clients sometimes who are expressing concern about programming the payroll system correctly and all the rest, but I think it's pretty straightforward at this point. You're going to add Roth. This slide on mid-year changes to simple IRAs. I think this is also a good change. The general rule for simple IRAs, it has to stay in place for an entire calendar year. We don't. A lot of our clients are larger. They may not. They might be too large to have a simple IRA, but sometimes we get acquisitions where there's a simple IRA, and it's always a little kind of frustrating that simple IRA plan has to sit there for an entire calendar year, and there's really no way to terminate it mid-year or do anything, really much of anything with it. So under this new rule, you can basically replace that simple IRA mid-year with a simple 401k or just a traditional safe harbor 401k plan. And it also, I think, helpfully, when you do replace the simple IRA with a safe harbor 401k plan, for example, the individuals who are in the simple IRA won't be subject to this 2-year holding period that typically applies. Normally, you can't roll your money out of a simple IRA into another plan until you've participated for at least 2 years. And that also creates some complication in just transitioning from a simple IRA to another plan. So I think this is a good change to be able to make. It's a little complicated though, because there's different deferral limits between a simple and the 402G deferral limit. And the legislation says you prorate that limit by day between the two plans. So there's going to be some level of complication, some guidance that we'll still need from the IRS about how this all will work, but this is a good change.
All right, just a few more things here that in the miscellaneous. And by the way, we did not cover everything in the act. We didn't attempt to because we knew you wouldn't have that much time, and we tried to focus on the most important. But there will be other things, and so don't think if we left something out that means it's not in the law. It just meant that we didn't have time and didn't feel it was as important as some of these other things. But here are a few other ones. One of the good things is that Congress has now required the establishment of a national online lost and found database. We have a number of employers that are dealing with the problems of missing participants, unresponsive participants. This would be a good thing where if they just don't respond, you can't find them, it gets sent over to a new database, or you have some other way of trying to find them, because that is a big problem right now. Congress has mandated that IRS keep in the self-correction for auto enrollment, auto increase failures. It's set to expire in EPCRS at the end of 2023. So now this makes it permanent, that they can't just not renew that, which is a good thing. Allows access to $1,000 penalty-free withdrawals for unforeseeable or immediate financial needs relating to personal or family emergency expenses. That will need some additional guidance to see, if you want to implement that, as well as penalty-free withdrawals for certain victims of domestic abuse. That's going to be another one of those where, determining how you certify that or determine whether somebody qualifies will take some additional guidance. The withdrawals for birth or adoption, new child can be repaid within 3 years. So that's a new limitation on it. The savers credit that's available is now going to be deposited into participants' accounts as opposed to paid back to them in taxes. So we'll have to see additional guidance on exactly how that's going to work. 403B plans can now participate in multiple employer plans. That was allowed under Secure Act 1.0 for 401k plans. 403B plans can now do that as well. The 403B hardship distribution rules have been modified, so they were now similar to 401k plans. There were some minor differences between the two about earnings and things like that are now will be gone in 2024. This is not effective yet. I'm not sure why they didn't make that effective immediately. That would have been nice. And there can be distributions of up to $2,500 from plans to pay for long-term care insurance premiums. So all of this stuff we will get additional guidance on. And I'm certainly sure we will discuss in more detail later once we get that. Finally, so a couple of good things that we can lead on, or we can finish up with, which is good. The deadline for adopting discretionary amendments to increase benefits. Right now, it is at the end of the current plan year. So you find out later after the end of the year, oh, you had a really good year. You'd like to give more money to the participants. Oh, sorry, you can't amend your plan to increase benefits. Beginning in 2024, you will be able to do that up until your tax return filing deadline. That's an excellent change. The last one is a little bit of a weird one, but it's not really directly related to retirement plans. But if you've been saving for kids' college education in a 529 plan, and it turns out you didn't use up all the money, it can now be transferred beginning in 2024 up to a lifetime limit of $35,000. You could be making a Roth IRA contribution for that individual, essentially. So if the limit is $6,000 or $7,000 for a Roth IRA contribution, you could do that over 4 or 5 years and use up to $35,000 of it, as opposed to having to pull the money out of the 529 plan and pay taxes on it, on the earnings, if you do not use it for college education expenses. So that's another thing. I'm sure you'll read about that in financial magazines, things like that. People will be touting to do that. So that's a good thing. Finally, there will be much more to come on all of this, not only from us, but obviously from the IRS and government, and there'll probably be some technical corrections, and we will continue to update you. I'm sure that some of our webinars for the rest of this year will cover some of this in more detail. Some of them may be more targeted as far as specific to governmentals, specific to tax exempts, or specific to certain types of plans. So look for that. And we thank you very much for your time and hope you have a great day.
Thank you.